What's up, guys? Brian Fellow Law Group L.L.C. with your Florida Law Weekly case update. Hope everybody's having a great summer so far. I know it's late July. Everybody's probably either on your vacation or wishing you were on vacation or something like that. But you're here with me this week, and that's great because we got 3 cases for you. First case is one of those where it's like, oh my gosh, I can't believe this happened to the plaintiffs or the people. They think they were counterclaimants, but basically this is a homeowners who countersued their general contractor for breach of contract for doing things on their home. They got a $500,000 jury verdict, but guess what? They get none of it. The whole thing got reversed. Why? Because their expert testified as to damages, not as of the breach of contract date, but as of the current date. So the case obviously went to trial, a couple of years later than when the actual last time the contractor worked on the house. And so instead of testifying as to what the repairs should have been as of that date, the last date that the contractor worked on the case, the breach of contract date, the expert testified what the cost to repair would be as of basically a couple months before trial, like the current cost to repair. Something that, that may be like an innocent type of mistake, and maybe you remand it back for a new calculation or something like that. No. If you testify or your expert testifies to the wrong date and you don't have any other evidence as of the date of the contract, the breach of contract, you're out of luck. And so the case got remanded with instructions for a verdict in favor of the contractor. So the homeowners who, if they had legitimate damages of $500,000 to their house, they get nothing. They get zero. Really tough break and really great reminder for lawyers and experts. Got to testify as of the relevant date, which is the breach of contract date. Next case is a family law case. It's a paternity case. This is on rehearing. I believe I talked about this previously. This is a case where the mother filed a petition to establish child support and for retroactive child support, and she filed it, I think, about a little less than 2 years before the child turned 18. What happened in this case was, this is a paternity, like I said, and the father was the one who had basically all the time sharing with the child from the original date of his petition to establish paternity back in 2010, I believe, until more recently the child lived with the father. So there was no child support order awarded when the father first obtained his paternity judgment. Apparently there's just no child support. I don't know how they got that past the judge, but they did. And so many years later, the daughter comes to live with the mom, and so she files a petition to establish child support. And so the issue in this case, the father filed a motion to dismiss because by the time the case got to the court, the child had already turned 18. And so the father was saying, well, now the court lacks jurisdiction to establish child support because the mom did not obtain a child support order before the child turned 18. And so the appellate court said, well, okay, here's the thing. And then the other thing that the father was saying was that the mother could only go back retroactively 24 months prior to his original petition to establish paternity way back in 2010 or 2011. And that was the relevant date that she could only potentially get retro child support, not for retro child support as of her current petition. The appellate court said, actually, no. The mother, while she can't get child support on an ongoing basis for the child after she turns 18, that's clear. She is still able to get child support for the period from when she filed her petition until the child turned 18 and the retroactive period of that 24 months prior to filing her petition. And so she's able to actually get child support regardless of whether the child turned 18 subsequently. She's able to get, number one, she's able to get child support for that period while filing of her child support petition until the child turns 18, and also retroactive 24 months from her petition, from the date of her petition. Didn't go back to the father's petition because in the father's pleadings when he first filed that, he was only asking for paternity. He was not asking in the wherefore clause for establishment of child support, and there was no child support established in the final judgment. Last case is a domestic violence case, and this is one of those I obviously it's not a laughing matter, but I almost chuckled because this is basically a case people were divorced, and the former wife is saying that the former husband is stalking her, And I picture this case of a former husband kind of wearing like one of those funny looking hats and disguise glasses, because that's what it was. The former wife was basically testifying that she saw somebody that obviously looked like the former husband, but he was wearing a hat and glasses trying to disguise his identity, and apparently he was stalking her, which obviously is a serious matter. But the former husband was saying, well, it's pure speculation. You didn't know it was me. I couldn't have been me. I was wearing a hat and glasses. How could you tell it was me? That's pure speculation. And so the appellate court said, well, we understand the law. You may be correct on the law that, a domestic violence injunction cannot be based on speculation. In this case, it was up to the trial court to determine which party the trial court believed. And so the trial court believed the former wife and believed that she could still identify her former husband even though he was wearing his hat and sunglasses. And so she was able to get her petition for stalking, for domestic violence for stalking. That was a valid petition, valid order from the judge. All right, guys, take care. I hope everybody has a wonderful rest of their summer. Hope to speak to you soon.